Today, we've got a special guest. We got David on here, commonly known as Batman, as his chair shows. And we're going to get into that story in just a second. But we're going to talk about a topic that is really one that goes back to the John D. Rockefellers. And I printed this out. I don't know if any of you can see this, but, you know, just like the thing that you said, that's John D. Rockefeller. And Nelson Rockefeller also said the same thing. Own nothing and control everything. You've heard this before, but you know, we can hear things throughout our lives and we can't really make sense of what does that mean? How do I own nothing but control everything? Well, that's what you're going to learn today. And you know, you all have been with me for a while. Some of you might be joining for the first time. Is there any newcomers here? If you guys could just chat in. If this is your first time here, welcome. And I hope this won't be the last time because this is a very valuable thing. Number one, I don't know if any of you got the link, you know, and you guys paid with the credit card, but if you didn't, if you could just do that right now, just go in and, you know, make your payment for today. I'm just kidding with you. It's free, folks. We don't charge for this. That's the beauty is I want all of you to get the knowledge that's in my head and in my mentors' heads and all the guests that we bring on. So you can learn what the wealthy do different than us. So you can learn how you can change little things and big things in your life that make a dramatic impact. And today we're going to talk about protection. We're going to talk about how you can control things while you're living, but also when we are in our final resting place, that graduation date, after that graduation date, how you still can control your affairs while you're not here. Think about that. The Rockefellers, every single generation, they get wealthier and wealthier and wealthier. Well, you may not understand exactly how that happens. You might just think their business interests go up and up. But if you look at I believe it's the Vanderbilts or the, there's an incredibly wealthy family, equally as wealthy as the Rockefellers. And a few generations after the main, Shauna, correct me if I'm wrong. I'm trying to think of the name. I think it's the Vanderbilts.
Rothschild.
What is it?
Rothschild.
Well, the Rothschilds still maintained their wealth, but there's one wealthy family, the Vanderbilts. Yeah, so I'm correct. The Vanderbilts lost their fortunes. And how is it that a family like the Vanderbilts can have these massive amounts of wealth, the same wealth that the Rockefellers would have, and then just a few short generations after the main Vanderbilt graduates, that wealth is dissipated, is gone. It almost seems impossible that much money can go away, but it can if you don't do proper planning. And that's the planning David's going to be talking about. So David, I'm going to turn it over to you and, you know, tell everybody a little bit about yourself. You've got, I mean, your bio is like 2 pages long. You've done an awful lot from real estate to businesses, helping people go from, you know, the W-2 to the self-employed world. But yeah, just give everybody just a quick summary of where you're at and what you do.
Yeah, absolutely. So the company that I work with and for is Nevada Corporate Headquarters, based out of Las Vegas, Nevada. I've been in business 31 years. Everybody sometimes tends to see the company and think of it as just a company that sets up corporations, and we're so much more than that. We have our own in-house law firm, CPA firm, retirement rollover division, business plan division, business credit division, trademark, estate planning attorneys, on and on. So I got in with them about 9 years ago. Prior to that, I was a relationship coach and a life coach. I was a relationship coach for about 2 years. And when it was just so much drama that it was overwhelming, I became a career coach to help people, as you said, move from becoming, you know, employees to employers. And that was a great transition. I loved it. And my wife and I had been involved with real estate investing. And so we had known who NCH was. We had actually talked to them about getting structured for some of our things that we were doing. And I decided to make the jump and went over to them. And at the same time, they were really steamrolling in the real estate investment space for the industry, and had a lot of speaking engagements. And I just absolutely love working, speaking, educating. That's my passion. So it was a perfect fit. 9 years later, here I am with you.
That's fantastic. Great story. And, you know, all of you, you know, you're just going to learn so much today because this stuff is fascinating. A lot of people, you know, when they hear someone talk about it, they think, oh, that's too complex, but it's really not if you know what to do and in what order to do it. And, you know, each of us are different in a lot of ways. You know, not all of us need the Cadillac of this, but, you know, certain pieces of this can be a huge thing. And it really is the reason we kind of decided to do this training is it is a perfect perfect fit for our real estate investor clients and also our money multiplier clients with the infinite banking, privatized banking concept. There couldn't be a more natural fit. And, before I have you open the PowerPoint, I just want to tell a little story. So any of you that are in real estate or getting into real estate, one of the things you've probably heard is most real estate investors, fear getting sued. And, a lot of us are saying, oh, I'm probably not going to get sued. Well, no, you will. It's just a matter of time if you're in real estate. I've been sued numerous times. And you know what? I used to get really nervous, would get the packet from the attorney that something happened at one of the properties. I mean, it was various things. I mean, all stupid things. But the most recent one is we had a BRRRR, which is a rental that we had created. And we had it rented out to the same girl for 5 years. Real great girl. And in the lease, we didn't allow dogs, but she went out and got herself a little puppy. It just happened to be a pit bull. Now, you can think what you want about pit bulls, good, bad, indifferent, but they're not allowed in our properties. We didn't know she had a dog. Then all of a sudden, we get served paperwork from our favorite attorneys in this area, which are the ambulance chasers, that this dog bit, I think, the neighbor or whoever it was, and we got sued. So why would we get sued when it wasn't our dog, it wasn't allowed in our lease, and it was our tenant? Well, welcome to real estate, folks. But you know what? I just laughed. I threw it down. I sent it over to my insurance company. They pay for all the attorneys. They've got it all, but we're protected. And we're protected because of some of the things you're going to hear today. But I could probably be more protected, which is why I want David to kind of educate me as well, because I think I'm protected this much and I need to be protected that much. So David, with that, let's roll into this thing. I'm going to try to answer questions as we go. But just so you know, David, as we're going, if there's a question that comes up, can you see the chats that are coming in?
I can see them.
Okay. So if there's one I think that's really relevant, I might kind of jump in and just say, hey, David, can we just answer this while we're on that topic? And, as long as that doesn't throw you off, that I think would be the most beneficial way to do it.
Not at all. I open up with live events. I always love questions, and sometimes we need to answer those right away. And sometimes they refer to everybody in the room because everybody else is thinking the same thing. So it's fantastic.
All right. Fantastic. All right. Well, let's roll into this training. I'm excited. And welcome to all of you that are joining us. I see there is a bunch of first timers here, and welcome to it. And anyone that's here, that has been, many times, thank you for coming back. This is going to be great.
Fantastic. Thanks, Chris. I appreciate the opportunity to speak to your followers, your loyal followers, for Webinar Wednesdays with Chris. So I'm excited. So we'll get right into it. So when we talk about estate planning, we talk about legacy planning. What we have to do is start at the bottom, where we're most exposed, and then work our way up to where we're most protected. So we have to understand what the process of probate is. Probate is an ugly word to some people. It's a great word to others. Chris, being a real estate investor, has probably looked at buying some probates. Probates are usually you're dealing with distressed property owners. Mom and dad's passed away. The kids get handed a property they don't want and need, and they don't want the liability or the property taxes on it. So probate is a process what they have to go through in order to get rid of that property. Understanding the last will and testament, what it means to you, what are the components of it. And then we get into what is the revocable living trust, how does that function, how does that get put together, the benefits, and then the difference between what it looks like if you have to go through probate versus if you go through the revocable living trust. And it's night and day. So probate is fairly simple. Probate simply means in Latin to prove up. Prove that you are the entitled heir to somebody's estate. And it's not always a relative. So we'll talk about that as well. But it is a judicial process of coming forward and saying, yes, that was my father, and here's the proof. Now, if you have a will, you have to go through probate. If you do not have a will, which is called intestate, means no will at all, you still have to go through probate. The difference is with a will, there is some direction as to who grandma wants to give away things to. So grandma passes away, she's got a will. In her will, there's going to be some things that are sketched out, okay? If she doesn't have a will, then it's a whole different situation. It's basically a free-for-all, let the battle begin, if you will. Unfortunately, in death sometimes, or excuse me, graduation day, the claws come out, right? Everybody kind of has their eye on that grandfather clock that's in the corner of the house that's been there for 50 years, and that's what they want. So who gets that? How does that get decided, right? So when there's not a will in place, that's a very difficult task to do. When there is a will, some of those items may be given to somebody, and there may be a lot of other things that are left unassigned. And that's just an additional headache. Minimal expense on something like that's around $3,500 to start going through the process, and it can get a lot more expensive as you'll see later on. So the process of probate, assuming that we're talking about family members, is that you provide the certificate of death, and then your birth certificate, and then a photo ID that's saying, here's my father or my mother that's passed. Here's my birth certificate that has their name on it, by the way. And then here's a picture of me and my driver's license that says who I am today. Now that's very typical when it's a direct family member. But imagine this. Imagine you're in a mall. I know it's COVID now, but imagine you're in a crowded, packed mall, and you stood up and you held a $100 bill in your hand. You stood up on top of a chair and said, hey, did anybody drop this $100 bill? How many people are going to raise their hands? Chris, what do you think?
Probably not too many.
I would think everybody would want a $100 bill. So that's the same situation. So when you go into probate, people come out of the woodworks. 5th cousins, 9th cousins, 12th cousins, somebody that looks like your cousin, right? You're opening yourself up to everybody wanting a piece of that estate. And so that's why there has to be some sort of a validation of who you are through the process. And that is what it's all about. We've seen cases where, you know, it's not limited to blood relatives. Could be a business partner, a drinking buddy, girlfriend, boyfriend, mistress, side dude, whatever you want to call them. Right down to that Nigerian prince that's been sending emails for 10 years. So anybody can try to make that claim that they deserve something from this money. And it gets kind of ugly. So the last will and testament simply expresses what your desires for distribution are. And this is your components of your will. So really, who do you want to get what, right? But it's a will. It can be challenged, it can be overturned, and they have been. There's some cases we'll talk about at the end here, some very famous people that have really not done themselves any justice or their families any justice by estate planning. But the distribution through a will is all at one time. And sometimes that's not good, depending upon who you're leaving things to. You know, Chris, you pass away and you got $1 million. Are you just going to give $1 million at one time to your kid?
That would probably be a big mistake.
Yeah, I'm just telling you. I mean, if you give a kid $10 and you send him into a candy store, he's going to come out with $10 in candy. So if you give a kid $1 million, man, that's going to be Lamborghinis and everything else. And yeah, okay, let's all say that we hope that we've educated our kids better than that. But yeah, money changes people very quickly, even family. Guarantees probate will occur. Again, if you have a will, just a will, you're going to go through probate. If you don't have a will, you're still going to go through probate. So it's going to happen. The distributions must be approved by the court, and it's called a testamentary letter that has to go out. So every time you do something, it's governed, and it's almost a mother may I in getting rid of this estate as this estate goes out. Now, there's also estates that are left with debt, and some of these things may be sold off. Every now and then you see, you're driving down the road and you see a sign that says estate sale or estate auction. And a lot of people don't really get what that is, but typically what that is maybe grandma's passed away. She didn't have proper estate planning. And so what we're doing now is we're having an auction to sell everything off to pay the probate so we can keep the big item, which is generally, you know, the home, the real estate. So, you know, estate planning is a very important part. It's not just for the wealthy, it's for anybody and everybody. A lot of people used to think it was only for the wealthy, and that's just not true. So last will and testament. So many predatory law firms troll the obituaries. You talked about ambulance chasers or attorneys that are sending these dog bite subpoenas or suits over to you. It's the same way with obituaries and dying. People are going to reach out and try to, you know, basically chase down and find out who the family members are. which is usually spelled out in the obituary. Thank you very much. It's like a calling card. David and Laura Vanlandingham out of Orlando, Florida. So now they know where to look for me. And they're going to reach out. They're going to call up and say, hey, David, I saw, my condolences. Your mother passed, your father passed. We'd like to represent the estate. So it's quite easy for them to find business. And it's kind of frowned on in practice, but it does happen. Probate requires absolute public disclosure of assets. So there's nothing private about probate. It is very wide open and everybody can see it. And that's, again, if you're a real estate investor, yeah, that's great. But if it's you and your family, it's not so great. We want to keep it private. Many of the different people who are involved have financial motivations, could right down to your attorney that's getting a probate fee, or a family attorney that says, oh, don't worry, we'll handle it, we'll take care of it. There's going to be a lot of people that have their fingers in the pie, and that's just not necessary. You must get judicial approval for the distributions. I mentioned testamentary letters before. So as we're getting rid of things, those testamentary letters have to go out showing who got what and what was that assessed value of whatever those items were. So very, very detailed when it comes to probate. So preparing for a revocable living trust is critical, simply because of exactly what you said. And I don't want to say you stole my thunder, but look at the slide, Chris. There you go. So
look at that.
Yes, the secret to success is to own nothing but control. So you're hearing two mentors tell you guys the same thing in less than probably 15, 20 minutes here. So it's critical, right? So in order to have a legacy and build and maintain and continually pass that down, this is the exact philosophy that you follow. We call it the Rockefeller principle. I know the Rockefellers are famous for many different ideas and many different wealth preservation techniques, but this is a key. It really is. So it was kind of funny that you showed that. So the revocable living trust avoids probate. Bottom line, that's a key part of the revocable living trust. If your parents pass away or a loved one passes away, it's a pretty traumatic time. The last thing you need is a very unpleasant process, which is what probate is. Probate can take years, many years. We'll talk here in a little bit about some of these probate cases that have gone 30 plus years and the estates still aren't settled. Typically, 9 to 18 months is typical in some states. Some states are easier than others. So it comes down to where you live or where the deceased live. So we have to figure that out as well. But we want to make sure that it's an easy process. It's a bad time, somebody's passed away. Let's not complicate that by probate. So it allows for the disposition of assets as directed. So you can separate your estate any way you want to. You can divide it up amongst the kids, 30, 25, 40, however you want to divide it up. You can also disinherit somebody if that comes that way as well. You want to avoid government involvement. So depending upon the values of the estates, we'll talk about some instruments that we utilize, depending upon how much you have in total assets, and it's calculated on the gross assets, and we'll talk about that in a little bit. There's different types of trust that we will do, different situations. So there's basically a single revocable living trust for somebody that's not married, obviously single. Whether they have kids or not, we have to look at things. So if they're single and something happens to them, who decides if we pull the plug on them or not? That's an important thing, right? Sometimes it could be default by somebody that you may not want to have that control to pull the plug. I know at times, in my situation as a single parent at one time, that would have been to my son. He would unplug me to charge his iPhone some days. So, that's a decision I don't want him to have. The marital trust is everything is together. It's pretty simple. Depending upon what state you live in, again, you may be in a community property state where it's going to be 50-50 anyways. If you're not, then you can also have what we refer to as a separate trust. So a husband has his trust, the wife has her trust, and there could be situations that have dictated that as a necessity, such as children from different marriages, assets from different marriages, inheritance that was passed directly to you. So Chris, if you had an inheritance that was passed directly to you, is that, community property? Could that be something that could be passed singularly through your trust or a marital trust? So these are all different situations. So there's no, cookie cutter answer for these things. This is why we have very in-depth consultations to find out, exactly what the state is. We want to talk about ownership or intended ownership of certain items, and how are they going to be passed down? Because if I've got a property that's a vacation home in Texas that was my parents', and it comes to me, do I want to pass it on to my children? Do I want to sell it? What do I want to do? And we'll talk about that as well. Generation skipping trust. These get used quite a bit. So generation skipping is exactly what it sounds. So if my parents decide that I'm doing well on my own and I don't need any of their money or inheritance, they can bypass me and go right to my 3 sons if that's the choice that they want to make. Because maybe I'm doing well. It could also be because I'm not doing well. I could be a degenerate, a bad parent, a gambler, drug addict, or whatever. And they decided, hey, if we just dump some more money on him, it's just going to be more. We would rather make sure that that money gets to the grandkids. So there's all different types of situations that will dictate this in putting together a revocable living trust. And when we send out worksheets, Chris, that really kind of is a great exercise. And we'll send you one so you can see what it's like. But it'd be great for you and your wife to sit down and kind of go through these worksheets together just to talk about things, because a lot of these things are things we don't consider. Right down to, Chris, what do you want played at your funeral?
Led Zeppelin.
There you go. Stairway to Heaven?
Stairway to Heaven. Exactly, of course. I mean, what other song?
AC/DC, Highway to Hell. So we're just on the same course. But yeah, I mean, right down to that. Where do you want to be buried? Do you want to be cremated? Do you want to, do you want to be interned? Do you want to, what do you want? So all of these things become a part of this, and these are things that we plan for. Sometimes we fail to plan for it. More importantly, it's not always about what we plan, but it's about what we failed to plan for. Who gets the family pet? That could be a good thing or a bad thing, right? So, mom passes away, she's got a dog, who gets it? So my sister and I have already got it worked out, so I'm just telling you, but those are things that come up. So generation skipping trusts are kind of important when it comes to either how well somebody is doing as a parent or maybe how not so well. So the revocable living trust, what is it? It's a contract. So it's enforceable. It's an enforceable contract. So a will is not so enforced. It's something that's just written down. A revocable living trust is a contract, and it as it is written, as it is done. So that's where you go to your grave with peace of mind, knowing this is exactly what you intended to happen. This is exactly who's getting what, and that's the way it's going to go down. Directives to take effect inter vivos, which is simply livings, Latin, or postmortem, graduation day. So the difference in a will and a trust is very big at this point, because the directives of the revocable living trust actually take action while you're still living. So when you're alive, you may be incapacitated. So you get into an accident or you're in a medically induced coma. You're not dead, you're not gone yet, maybe halfway there, but you're not there yet. So you still have control of your assets, and you have responsibilities for those assets. You may have car payments, house payments, credit card payments. So who handles those financial affairs for you during that time that you're incapacitated? So that's one way that it kicks in. And of course, upon graduation day, then yes, in full force, it'll direct out who gets what. Again, it avoids probate, controls your assets. Revocable versus irrevocable. We get this a lot. A lot of people will call us up and say, I want an irrevocable trust. And a lot of times it's just a simple misunderstanding as to what the difference is. Real simple, a revocable living trust is yours. It is your assets. It's attributed to your net worth or your gross worth when you pass away. An irrevocable is simply not yours any longer. Let me give you an example. One that you're probably familiar with, Chris, is an irrevocable life insurance trust.
Heck yeah. I know exactly what those are.
So if you have a high-end policy and you don't want it to count towards your personal net worth, and think about it, is the life insurance for you? No, it's for who it's being left to in this sense of the word, in the irrevocable. So if you have a high dollar insurance policy, we may take that out of your personal estate and place it into an irrevocable trust, which means it's no longer a part of your calculation of net worth. And upon death, then it goes out to your intended beneficiaries, much like a regular life insurance policy.
Another way you could do it is, you could just keep ownership of the policy because you want control of the money that you're using, and how we do it with the banking systems, but then have the trust set up so that the beneficiary is the trust and the money goes into the trust so that you control the money, in your final resting place on your walk up the stairway to heaven.
There you go, or down that stairway.
Oh,
so either way. So the beautiful thing about it is again, when we're doing our consultations, we want to find out if we're working with high net worth clients, and we've got professional athletes and rock stars and movie stars that might have high value assets that we want to stick into a form of an irrevocable trust to remove it from their own personal estate. But on the other side of the coin as well, they may have a high dollar home that they want to keep in the family for generations and generations to come. So by putting a property into a irrevocable trust, what happens is upon death, if your family members decide to get rid of it and sell it, financially it's uncomfortable for them because there's a nice tax that goes along with that. So it's a little bit different from a revocable living trust being passed on, getting that step up in cost basis versus okay, well, you're getting rid of something that was meant to be kept in the family forever. Now there's a little bit of an uncomfortable tax for you as well.
Yeah, it's funny that you mentioned that, David, because everything we always talk about is one of the biggest problems in this country with money is we are not in control of it. And you just mentioned that, it's all about controlling your assets. The Rockefellers knew this. The Rothschilds knew this. The Vanderbilts, they didn't know this, and you see the outcome. So I'm glad you brought that up. I love that, that word control, especially when it comes to having control of your money.
Absolutely. And that's the crazy thing. And again, we're going to talk about towards the end about mistakes other people have made. But when you look at families like the Vanderbilts, right, you would think that they've got good people, a good team of advisors around them. I'm just going to give you a perfect example. The education that you provide to your clients and to your followers is amazing, because these are things that typically people of high wealth value have access to. But there's also a bunch of people out there that have access that just don't do it. And whether it's because they're afraid to admit that they're going to meet their maker someday and it's just too real for them to sit down and focus on doing this, it's procrastination. We'll talk about that as well.
So here's an interesting, before we move on, this is a great question. I was actually just typing the answer, but I think everybody would like to know this. Nathan said he's been told, and I don't know whether it was by his attorney or that, but if the trust is the beneficiary of the life insurance, then it can be taxed. However, if it's to a direct person, then it's not taxed. Is this correct? Do you want to take that one? I was kind of typing an answer, but there's a couple answers to that one.
Well, yeah, there's more details that are actually needed to determine whether it's taxable or not. So if you want to kick that off from your side and I'll follow up, we can do that.
Wonderful. All right. We'll catch up with that one in a bit, Nathan.
All right. So required capacities of the trust, they have grantors, and grantor is basically the person that creates it. It may be created by an attorney, but it's created for you. It's for Chris. So Chris would be the grantor. He would have trustees. He would also have beneficiaries, and that would be the main components of the trust. So the party establishing is the grantor or the trustee, and then you would have what's called a successor trustee. So in the absence of Chris's capabilities, whether it's incapacitation or graduation day, somebody else steps in as that successor trustee. In a marital trust, you are your spouse's successor trustee. So if Chris passes away, Chris's wife takes that responsibility and that role. So beneficiaries are who you desire. Who do you want to take care of? Family members, minor children, friends, organizations. A lot of people leave money to organizations, and you'll read about this all the time. When Ray Charles passed away, he had, I think, 11 or 12 kids, busy guy. He left a lot to his organization, which, believe it or not, for a blind person, it was actually to a organization for deaf people. In addition to, he gave his right of publicity, it's called an ROP, a right of publicity, to that same organization. Because we always talk about what is the worth of somebody, their net worth when they're living versus when they've passed on. And, you know, we can talk about the icons and Elvis and Michael Jackson and, you know, whoever else, and how they've actually earned more in death from right of publicity versus, you know, when they were living. So there's all these little things that we have to talk about. Now, you know, a lot of us, we're not famous, we don't have right of publicity, but guess what? A lot of things that Chris is doing and building to someday is going to be a system that he's developed, he's put his stamp on, and someday when he meets his maker and this process still continues and somebody picks up the reins and takes over for him, you know, his legacy continues on, and that's what's important. The original grantor may serve as all three simultaneously. Again, what if you're a single person, right? So you are the grantor, you are the trustee, and then you are potentially the beneficiary until you decide who to give that to. So the freedom's a great word. The trust may be revoked at any time. That's why it's called a revocable living trust. It's not permanent. We can make changes anytime we want to make changes. We could take somebody out, we could add somebody back in. I'm not saying hold that over your kid's head and tell them, hey, I'm going to disinherit you if you don't get your algebra grade up. That's not what it's about. The trust may be amended or restated at any time. So trusts are things that are just not there permanent. Put them on a shelf and leave them alone. We're constantly, especially as business owners, we're constantly adding things to it. We'll talk about continuation plans for the business here in a second. A trust can change with the grantor or the testor circumstances. You're in a marriage and then you're in a divorce. What happens to the trust? How do we unwind that? How do we split that off and create two new trusts? So there's different situations that will cause for different things. Spendthrift provisions. We talked about dumping a bunch of money on kids. May not be such a great idea. We'll follow up with that here in just a second. So keeping control of assets.
Hey, David, real quick, David, I just don't want to miss this one because this is a good one. How often should this stuff be reviewed and revisited? And I know Holly had a question about this too, because she had a lot of things happen. I'm not going to kind of mention it unless she wants to, but you know, a lot of things in life change. You set this plan up, you know, you build the trust and everything, but then things change. People, you know, have medical conditions. Maybe the executor is no longer with us or incapacitated. I mean, what is the general standard for how often this should be reviewed?
I think it's going to be, you know, case by case with everybody. So, you know, really what I do is I look at everything from my corporate record books to my trust, everything on a quarterly basis. Okay, I try to make sure I don't want to, you know, wait till the end of the year to make sure everything's in order because, you know, I might not see the end of the year. So I want to make sure things are done. You can do it monthly, you can do it quarterly, but we really, you know, you should, you know, have certain things in there. Birth of a new child, right? So there's certain things that need to be done right away. Purchase a new home, take the old home out of the trust if you sold it, place a new home into the trust. And you went out and bought a new life insurance policy. If you're going to name the benefactor of that, the trust, that needs to be done. So I think it's not set it and forget it kind of thing. It's something that you pay attention to and maintain. It's very important. So why not give it the attention that it deserves?
Perfect.
All right. Keep control of your assets, even in capacity. We talked a little bit about this, but again, you know, there's been some very famous cases where people have been on life support for many years, probably beyond what they wanted or intended, but they've got assets and they've got an estate that's paying for that. And how much of that money are we going to burn through before pulling the plug on this poor individual that's incapacitated or on life support? Tough decisions, tough conversations, tough thought process to go through. But I'm telling you, once you go through it, you'll sleep a lot better knowing that these things are taken care of. Again, most of these things we've never considered before. Stay out of court. That's the greatest rule. Stay out of court. You talk about going to court on a rental property, you stay out of court. If we can avoid court by having a trust versus having to go through the probate process, by all means, definitely do it. You can still invest, buy, and sell out of the trust in the trust. You've got a property, your home is in the trust, you want to sell it, it can be removed and sold out. So it's pretty easy. So it doesn't really limit you from doing any of those activities. As a matter of fact, you can do them with greater confidence because there is some level of privacy and protection there. Your only title changes to these assets. So we'll talk about how to do this in a second, but it's very important to understand that we want to follow the Rockefeller principle, and we'll talk more about how we do that. Business continuation, we run into this a lot. So a lot of our real estate investors, husbands and wives, sometimes it's the wife's company, the husband's really not on board, or he doesn't want to be involved, or vice versa. So how do we protect the marital unit? So if the wife is on the business and the husband is not, the wife passes away, that business still has to go through probate unless there's a trust involved. So there could be assets in the business, there could be cash in the business. We don't know. So there has to be a mechanism that will allow us as a surviving spouse to take control of those assets. And it's as simple as, with a corporation, you're going to assign your stock certificates over 100% to the Revocable Living Trust. In an LLC, you're going to assign your membership certificates, a different name, same process, over 100% to the Revocable Living Trust. So it's a business continuation plan. And you've got about a year really to clean all that up and decide if you're going to keep the business, up and running. Then you're obviously going to have to reapply for an EIN number. If your spouse passes away, one of the things that a lot of people ask is, hey, with the trust, do I need an EIN number? My answer to that is not yet. You will get an EIN number when you pass away. So the EIN number is assigned to the trust, which is, if you think about it, when you set up a corporation or an LLC, you have to provide your social security number to obtain an EIN number. So these things are all connected. So upon the death of the spouse, the entity, through the membership certificates mechanism, falls into the trust. The husband then decides, surviving spouse decides, am I going to shut the business down? Am I going to keep it going? What do I want to do? If they want to keep it going, they're going to reapply for a new EIN number and swap them out, keep the same business moving forward, that's fine. If they want to unwind it, then there's a process to do that as well. But it gives you the flexibility in business continuation to make sure that whichever direction you want to go, whatever choice you want, is available to you. And that's most important. So probate, let's talk about numbers. Love numbers. So if we look at it, and I'm just going to say a typical estate. So some people may say this could be atypical. But a typical estate, your probate fees can range from a flat fee to commonly, 5% up to, I've heard as high as 9%. 9% in this case, it would be $95,000, $96,000, quite a bit of money. So if we look at the gross value of your assets, so you bought a house, it's worth $400,000. You may have $10,000 in equity, but the gross value is still going to be $400 for settling the estate. So if you take your other real estate, you've got a beach house or a condo somewhere, art, antiques, jewelry, $25,000, personal assets, $100,000, securities, $100,000, savings, vehicles, there's your number 2 Audi, I believe, at $40,000. Life insurance policy, right? So all these things total up to $1,060,000. Well, at 5%, that's $53,000 that somebody's going to have to pony up in probate fees. Now, 9%, like I said, $95,400, something like that, right? So very, very expensive. Now, some people will say, well, let's beat this. Let's get that big asset out of there by doing this, joint tenancy. So let's just do this. Let's slap my name on my mother's home. And if she passes, it doesn't go to probate yet. It will when I pass, but not when she passes. but let's talk about the complications of having 2 or more people hold title to that property. So with what's called joint tenants with rights of survivorship, okay? Your children's legal problem may affect you. So if I put my name on my mother's house and I do something and I just, let's just say, had a few too many beers watching Sunday football, drive home, get nailed for an accident and DUI and all those good things, and I've got a legal issue. Is her property at risk? Absolutely it is. Under joint tenancy rights of survivorship, it is. Exposes one co-owner to the credit risk of another co-owner. So what happens if I'm just that degenerate son that runs up a bunch of credit, doesn't pay, creditors start coming after me, they're going to look to see what I own and what can they move against. Even if they can't force the sale on the courthouse steps, what they potentially could, they could still put a lien on the property. That's another problem. Under joint tenancy, and the surviving parent cannot borrow or refinance the property without the children's approval. So you want to talk about, you know, having the advantage now on your parents, you know, there you go. So that's something that's concerning. Bank accounts, any joint owner can close an account. Joint ownership with married children can create problems. If there's a divorce in the family, now what happens? Are we in a community property state? My mother's fine, but myself, my wife are getting divorced. We're in a community property state, so she gets half of that. Am I forced to sell? There's all kinds of things that are going to start making this not as attractive as we thought originally. Remarriage by the spouse can disinherit children. So there's another thing that affects the lineage, the downline. If your child is a joint tenant on your home, 1/2 of the home receives a step up in cost basis. We kind of alluded to cost basis earlier. So typically, if my mother passes away, God forbid, my mother passes away, and she bought her house 20 years ago for $200,000, and today it's worth, you know, $800,000, then I receive a step up in cost basis and a valuation of what that property is worth the day that she died. And if I sold that property for exactly what it was valuated at, I don't pay a penny of capital gains. But in this case, I would only get half of her step up. So that would create an issue in addition to my monies, because if I just now recently put myself on there and the value was $700,000 or $600,000 when I did, if I sold the property, I would have to pay capital gains on the difference as well. So from a financial standpoint, it's just a horrible idea. It's a bad idea. And a lot of people try to do it because, you know, their buddy they were talking to knows a buddy that knows a buddy, and they said, hey, this is a good thing to do. Know who your circle of friends are. And if you're the smartest one in your circle, change circles. Control the assets if you should become incapacitated. We talked a little bit about this, but you could make provisions for things, you know, that have to be sold off. Let's say you're incapacitated, you're on life support. What are you willing to burn through financially to hopefully come out of this thing alive, right? And we also don't want to wake up, you know, from a coma and be in bankruptcy. So what do we need to do to maintain ourselves while we're incapacitated financially? What kind of assets can we dump? Are we talking about, cashing out our 401ks? Are we talking about, tapping into money market accounts? So what is going to help us with continuation for those debts? Control of disposition of assets. We talked a little bit about that. Who gets what, when, how. And minor children. This is a great picture. I don't know, did you see the picture of the minor child? That was very difficult to find. That is a actual minor child there. Can be provided for incrementally. So again, we're talking about not dumping a big chunk of change on them. We're talking about graduated. And, we can do that over a lot of different benchmarks that we want them to hit in their lives. Special needs provisions. If you have a child that, has something that medically they're going to need special needs and care for a long term, we can set something up, or we can actually set up what's called a special needs trust, separate to what your provisions are. Maintenance money to maintain. We've got several clients that have children that have cerebral palsy and Down syndrome, where they're going to outlive their parents, and they're going to need that money for care. So when we talk about spendthrift trusts earlier, we talk about providing for incrementally with distributions. This is very important, how you want to do it. So do you want to, give your child, 10% of their inheritance or 20% or a certain dollar figure upon turning, 18, 21, 25, 30? You know what? Graduate college, you get this much. Go to buy your first home, you get this much towards your first home. So what are those benchmarks that we want to set so that knowing, from the grave, and this is a way to kind of rule from the grave. It's could be humorous for us parents and not so humorous for the kids, but we can still control our kids' lives somewhat from the grave, because we have certain things that they have to do. I had a client, 5 or 6 years ago. I'm glad this wasn't my father. Let's just put it this way. But he wanted his daughters to read. He had 2 daughters, and he wanted them to read a certain book and then really, write a book report on them and what they learned and what they got out of it. And if they didn't do that, they didn't get their first lump of money. I've seen other people where they had big chunks of money that were going to go out to a kid, a couple $100,000, and they said, well, here's how we're going to do this. You're going to get your first 100,000 at this benchmark, but you must donate 50% of that to a charitable organization. Teach them how to live off the 50, not the 100. And then upon the second distribution of the 100,000, they got to keep all of that. So all of these things are in your control. So you can be as freakish about it as you want to, and controlling your kids' lives after you've passed, or you could just caution to the wind, throw them the money and say, it's up to you, figure it out. But it is your discretion. You have the control. That's the beautiful thing about it. So the processes of going through probate through a will, or not going through probate with a living trust, completely opposite. With the will, as we talked about, there's going to be attorneys involved, 1, possibly 2-year delayed of distributions. Somebody comes up and says, no, that's mine, or, Dad told me I can have that. There's going to be some infighting there. There's going to be some problems. Public disclosure of your assets, debts, and who the heirs are. All of this stuff is for public knowledge, again. And sometimes people are reached out to by attorneys that they don't even know somebody passed, and they're like, hey, your uncle passed away, and you're potentially going to be left something. So a lot of people are putting their fingers in the pie at an early part of the stage. Maximum emotional impact on the family. It's very stressful to go through this. It's just the worst time in the world to be fighting. This is a time when everybody needs to come together, kumbaya, and pay their respects and do the right thing. But it just doesn't happen that way often. Court-appointed guardians and conservators, this is a killer. When people fail to plan that have kids, and this is a big one with me. When people fail to plan with kids and something happens to the parents are out driving to the mall, they get into an accident, the kids are at home, parents have their graduation day, what happens to the kids? The process of what happens to the kids is horrible. Those kids immediately should be remanded to family members, people they're familiar with, and it's not always that way. They could go to Child Protective Services, then to a temporary foster care until a judge appoints guardianship. It's just not a good thing. And if the kids have a wider age range, they may be separated. They may be going different places. And that's just, what a nightmare for a child having to deal with something like that. So that's a big issue for me. The expense of probate fees, we talked about how it's calculated and the fees associated with that. Estate taxes, look, even people that are rich make mistakes, and we'll point out some people that didn't have these things in place and got nailed with estate taxes because they weren't sharp enough to divide up these assets between revocable and irrevocable products. The easily contested, again, you can have somebody show up and go, hey, wait a minute, no, your dad said I could have that truck. Him and I have been driving the fishing hole, for 10 years in that truck every weekend. He told me that, yeah, if you die, I get all of his fishing gear and I get that truck. Well, could that slow things down? Yes, it could. So totally public and court control once again. On the other side, it's real simple. No attorneys, no court control, no probate, no guardians, no conservatives, no houses, no delays, no unnecessary expenses, no unnecessary taxes, no contest clause, dual federal estate tax exemptions for couples, totally private and family controlled. Now, let me go back to something here. No contest clause. This is something that can be written in. And I giggle about this because I know people that have done this, and it's been done in my family. So some people always say, oh, everybody has a creepy uncle in your family or a greedy uncle in your family. So in your trust, let's just say I had a grandmother who was pretty sharp, and she passed away at 104. But she knew there was potentially a person in the family that might not disagree with her last wishes and distributions of those wishes. So being the sharp woman, she wrote out 10 checks to each of us for $1. That if anybody complained, made disparaging remarks, or tried to contest anything, they would get a check for $1 and disinherited from everything else. So wow, yeah, you can really control these things way beyond the grave. A lot of fun. Operations of the trust, quite simple. We create the revocable living trust and everything flows into it. Pour over will sometimes is referred to as what's called a spillover will. Same thing. And what that is a legal instrument that catches assets that were left out of the trust. So as we were talking about shoring up monthly, quarterly, or hopefully not at a year, but as we're going through making sure that, hey, listen, I acquired something new, it needs to be into the trust. If you passed away and something was left outside of the trust, the pour over will grabs it and brings it into the trust for us, okay? The retitling of assets, very, very important. Everybody would assume, my last name is Vanlandingham. Everybody would assume that I have the Vanlandingham family trust. Well, does that follow own nothing, control everything? So if I have a house and I buy my house with my wife and I title it in our name when we buy it, is that an exposed asset, yes or no? Absolutely it is, okay? If I take that house and I quit claim it into my revocable living trust that's named after me, the Vanlandingham family trust, is it still exposed? Yes, it is. So legally, the name can be disconnected, which means it doesn't have to be named after you. So the Bruno family trust is the name of my trust. Bruno was my English bulldog. He was like a fourth son to me, passed away many years ago. It also sounds kind of mafia, right? Nobody's going to mess with the Bruno family. So we take all of our assets and we put it into the Bruno family trust. It's not connected to our name. So if anybody's ever poking around looking for what we have, it's really not associated with our name, okay? So the heirs and the devisees, we say heirs because those are family members. Devisees could be anybody, family members, organizations, non-family members, are the ones that are going to receive as beneficiaries the items in the trust. So you have your instructions to the successor trustee on how to distribute your assets after your death, and that is their responsibility, okay? Now, when we talk about trust, a lot of people say, well, geez, you know, if I take my home and I put it into my revocable living trust, am I going to lose my mortgage interest? The answer is no, you're not going to. And also you see no reassessment of property tax as well, which is pretty important to a lot of people in states where property tax is quite ridiculous.
New York.
New York, Pennsylvania, yeah, I didn't want to really point anybody out, but you
Oh, that's okay. I'll point that one out.
Yeah, not real friendly. Estate tax exemption has been increased. And this is one of the reasons why we don't do as many irrevocable trusts as we do, because the estate tax exemption level at one time was $1 million and it was up to 5 million. Under Bush, it went up to 5 million. So these things change. In this climate right now, we're at 11.58 million per person. So a married couple is $23.16 million, okay? But in 2011, they changed that as how that can be broken up. Prior to 2011, that figure, which was probably closer to 10 million for a married couple, was 5 million for the husband, 5 million for the wife. Now in 2011, they passed a law that simply states that 23.6 can be used independently. So if the husband dies and his estate's worth 6 million, then he's only going to use 6 of the 23. 0.16, because the surviving spouse could take the rest of the assets, grow and build and continue that legacy, and still be protected by the estate tax exemption here. So that was something new that came out in 2011. Pretty important information there. So estate planning, we have our revocable living trust, we have the pour-over will, we have durable power of attorney for healthcare. That's a little bit different than our living will declaration, or sometimes, that is your extension of life. Pull the plug, don't pull the plug. The durable power of attorney for healthcare could be as simple as you're knocked unconscious and you need a surgery. Who can say, operate on my son, my daughter, my brother, sister, whoever. Again, if you're in a medically induced coma and you need some type of surgery, who can sign off on that? The durable power of attorney for financial is quite simple again. Who do you trust to maintain your finances if you're incapacitated? Usually, it's probably the same person that you trust with your children if you've appointed a guardian for your children. The reason those two usually go hand in hand is because the kids are going to need maintenance money. And let me tell you, some people will sit there and say, well, I don't have anything, I'm broke. Nobody wants my kids because there's no maintenance money. Well, let me just tell you, when you make money, everybody wants your kids. People will come out of the woodwork to say, I'll take your kids, I love them. I've never met them, but I love them and I'll take them and I'll care for them as my own. The certificate or abstract of trust is important because when we take an asset like your home that's titled in your name, and then we quitclaim it into the trust, which obviously now has a different name, we need to provide an abstract of trust or a certificate of trust to your mortgage company, lending company, financial institution to say, hey, here's this piece of paper that says David and Laura Vanlandingham are the Bruno Family Trust. Okay, so it just certifies that that is us. Sometimes you'll get a notice from the bank and they'll go, hey, we noticed there was a change of title, what's going on? You send a copy of that. What we recommend is send that to anybody you're going to change, whether it's bank accounts, money market accounts, life insurance, anything. Make sure that they have a copy of that. You don't need to provide them your entire revocable living trust. It's none of their business what's in there, by the way. The only thing that they need to see is that abstract of trust or certificate of trust. That's all their business is. Anything else is private and not really for their eyes. Final wishes and electronic keys. Final wishes is kind of what we were talking about. How do you want to be buried? Where do you want to be buried? What songs do you want to play? Cremation, what do you want? So that's important. Electronic keys, the more and more and more we get into this world of electronics, that's really important. So, you pass away, who do you want to have access to your passwords, your Facebook account, your Instagram account, right? Bank account, all of these accounts, everything that we do. Think how many passwords we got jumbled in our mind. And who do we trust with all those to do the right things? Whether to, shut the accounts down, close them down, keep them open as a memorial page, or simply erase anything and everything you've done since you started the account, right? So who's that person? Who's your best bud that you trust with that delicate, sensitive information? So that's your electronic keys. Procrastination, here we go. So everybody procrastinates. And this is one thing. This is why you're going to see a massive list here in a second of people that procrastinated, didn't get these things done. Death is inevitable. It's going to happen. Accepting your mortality is something that we have to do. Just like you're accepting that I'm going to succeed, I'm going to be successful in life, and I'm going to leave it to people to carry that torch for me. Well, guess what? If you don't light the torch, it's not a torch, it's a stick. So in order to pass it the right way, these are things you got to do. You must do these things. They're very, very important. Nomination of guardians for the children, man, I can't think of anything more precious than that. It's, out of all the things I have, those are my assets. Those are my most precious assets, are the children.
Let me ask you a question about that, the guardian. I mean, that's a tough one. I mean, who do you pick? I mean, do you pick a family member, a totally disinterested person? I mean, I know it's different for everybody, but I mean, if somebody's like looking at this saying, I need to do this stuff, but like, who would I nominate as the guardian of all these important decisions? Like, what would you say would be a simple place to start?
So let me just ask you a question before I hang myself. Is this going to be available to the general public?
What's that?
This video?
Oh, no, just this group. The only people that get this video are the people in this recording right now.
I don't want to offend anybody, family members who I wouldn't trust, but let's just be real. You know, nobody's more loving than my mother, but she's 84, right? I've got a 12-year-old son, I got a 15-year-old son, and I got a son from my first marriage that's 26, right? So my mother's probably not the best choice for longevity. My sister would be a great choice. She's in Texas, but she's also an empty nester, and she'd probably hate me. She loves my kids, but she's like, hey, I just raised 3 and got it done. I'm not ready to start over again with 2 more. So that's a great point, Chris. What would you look for in those individuals to take care of those children? You know, obviously somebody responsible, right? Obviously somebody hopefully in the area that you live, right? So you're not breaking up, changing schools, and going through all the traumatic things that are going to happen. Because again, kids just lost their parents. We want to keep some sense of normalcy for them. So hopefully we would keep them connected to the same neighborhood, the same friends, the same schools. In my case, it's somebody in our neighborhood, and it's the godparents to my kids, and we're the godparents to their kids. And we just have that agreement because I know them very well. She's an attorney. He's a retired Chicago police officer. And, you know, we're family. You know, blood does not dictate family sometimes. So we trust them implicitly. We trust them with our finances, our money, and we trust them with our kids. So it becomes a great conversation. So like I said, when you have the worksheets and you're going through these worksheets, it can start a dialogue or an argument one way or the other. But, you know, again, these are adult conversations we have to have. What is at stake? Our kids. You know, it's almost like we're going to put ourselves in a room, lock ourselves in a room until we come out with something that we can agree on what's best for them. Not who we're going to offend, not who we're not going to offend. And look, there's grandparents' rights out there as well. All of these things are out there. So you're not really taking the kids away from anybody. You're just making one person uber responsible. That helps, I think.
Yeah, it does. It's a tough one. I mean, it'd be a hard one for me.
It is. It is difficult. It really is. If not now, when? One of the greatest sayings ever. You know, if not now, when? Now. This is the time to do it. Whether you're in business, starting a business, thinking about starting a business, have kids, don't have kids, all these elements, the different elements that we've covered today are applicable to you, right? So maybe you don't have kids. Maybe you don't have to worry about that. But you sure as heck want control over your body and what happens to it. And you don't want somebody to pop up and dispute that. So all of these things probably cover, I would hope, 100% of the people that are listening today. Live life, this is one of my favorite sayings. And I don't know if I made it up or I came up with it or I just woke up and heard it in a dream, but live life to the fullest, but die responsibly. You know, live life to it. Don't be afraid of life, live it. But just make sure that when graduation day hits, things are in order and we're taking care of what needs to be taken care of. Those are the important aspects. Now, here's a fun list.
Oh, geez, this is a good one.
Yeah. Abraham Lincoln died without a will. He was an attorney, Chris. He was an attorney, right? I can go through every one of these. We've got stories on every single one. We all know the saga with Prince. I mean, Prince died without anything. He wasn't expecting to die, right? He had, I mean, estate worth over $300 million, probably closer to $500 million. 29 people stepped forward and claimed that they were a relative. One person, one gentleman that was incarcerated claimed that he was the love child of a tryst that Prince had with his mother. DNA proved that not to be true, but I mean, these are things that are going on. Rights of publicity, you know, with Prince, my God, how big is that? Think of Elvis, think of, you know, Kurt Cobain, think of all these other people, Whitney Houston, right? Aretha Franklin, all these people, rights of publicity is huge.
Howard Hughes, are you kidding me? He was surrounded by attorneys every day of his life.
Exactly. That's the craziness. James Gandolfini, how about this? Worth $80 million, only had he had a will, which they determined is what they utilized. So when he passed away, his wealth went from, through estate taxes, went from 80 million down to 40 million. And then they found out that he had some trusts set up, but never funded them. So they never became operational, right? So some people know they need to do the right thing, but they don't complete the task, which is crazy. But if you look at this entire list, I mean, Joe Robbie, former owner of the Miami Dolphins, okay? They owned 85% of the Miami Dolphins and 50% of the stadium, okay? When he passed away, there was 9 kids, and actually his wife passed away 22 months after he did. So this whole, the kids probably killed her because they were fighting. She disinherited 4 out of the 9 kids. And they ended up selling the entire estate and their share in the team in the stadium for $109 million and paid $43 million in taxes on that, estate taxes. 15 years later, the Dolphins were sold for $1 billion. So again, failing to plan. And I mean, I could go on and on. Here's one, Steve McNair. Let's say taking care of mom, right? Taking care of mom's important. Steve McNair, incredible athlete, loved him as a quarterback. Bought his mother $1 million home, but it was in his name and attached to his estate. Steve McNair had an affair. It's public knowledge. Something went wrong. His mistress killed him. The spouse, of course, inherits everything through the trust, including mom's home, Steve McNair's mom's home. Well, the widow, and I'm going to say jilted widow, decided to start charging mom $3,000 a month in rent.
I would come out of the grave. I would literally come out of the grave over something like that.
Yeah. So mom, being a little somewhat spiteful, when she couldn't afford it, she moved out and took $53,000 worth of appliances and items in the house, and then was sued by the estate for those items. So, you know, we go on and on and on. You know, Barry White got separated, never got divorced, had a live-in girlfriend. And when he died, he was still married. His estate went to his wife, 20 million. So the final score, 20 million wife, 0 girlfriend. You know, so these are all just, you know, different examples of people. Casey Kasem, that was really not about money. That was about control of him and himself as he was going through the dementia that he went through. And then where he was going to be cared for, and then actually where he was going to be buried. So all of these things are crazy. But if you look at the names, you're going, my God, you know, who was advising these people? Or better yet, who wasn't advising these people and why? You know, it's just absolutely 100% amazing that these things happen. And, you know, some of these people died young and they didn't expect to die young, obviously. But this is why, you know, if not now, when? This is why it's now. None of us expect to die. None of us really have the benefit of knowing what that date's going to be. I guess in certain circumstances, somebody could. But for the most part, if these things aren't cleaned up and cleared up and fixed and done right, your name might as well be on that list as well. I'll be talking about you. But this is public knowledge. There's some great stuff out there on this. If you go and look at it, Chief Justice Warren Berger wrote his own will, 187 words. But that didn't keep it going from probate. So more and more and more. So revocable living trust buys peace of mind, helps you sleep at night, gives your heirs direction, provides some restraints of the use of the inheritance. We talked about pulling back, putting it out graduated, and it's affordable. And it's affordable not to have one. You should have one. Absolutely. It's just not that big of a deal financially, depending upon what type of trust. And again, we have various different ones, and that's why we do the consultations to make sure that, you know, we're putting you in the right vehicle for where you're at. That may change, but we need a starting point. So what we're doing basically is allowing your people to either text us and text NCHRLT to the number 31996, or they can simply call 866-545-3281 to schedule a free consultation. They have questions about things that we talked about, or they're interested in recognizing now. We kind of exposed everybody, so everybody on this call should actually know this is something that they need. They can't act like they've never heard of it and they don't need it now. I'm actually going to probably facilitate the first 10 appointments that we get scheduled. They'll be working directly with me. We've got a fantastic team at NCH. So if you're not working with me, don't worry. We've got other you know, top level consultants and analysts there as well. But we want to make sure that everybody understands this generational wealth and carrying that legacy forward is important. And this is the key vehicle that does that.
I think that was great. And, I think I can talk on this, and, I'm embarrassed. I've got a lot of assets, and I've done many wills in the past. I've had trusts set up, and, I just, I don't do a good job. And I've been kind of chatting with some of you on here, and, I think we all, we set this stuff up, but we just fail to really review it, and we fail to keep it up to date. Cause I'm thinking about the last will I did, and I'm like, holy crap, I got to change some things, because there's some people listed in that will that I don't want getting anything anymore. I mean, things in life change, and therefore you need to change things. And also it's sick to see that list. And, I've heard of all those stories, but it's sick to see that. And it's like, I don't want to be on that list.
No.
I don't know. It's I think the big reason why a lot of those people are on that list is this is that one thing we don't want to think about. This is that thing we say, truth hurts. It's hard to discuss that. It's hard to discuss who's going to get this, who's going to get that, what happens when I'm no longer here. It's easy to be here and be like, I'll figure it out. Well, we don't control when we're here and when we're not. I mean, that's not in our hands. And I think, like you said, your statement, your quote that you came up with, that's perfect. I mean, now is the time. My watch says it now. It's the only time. And believe me, I'm going to be on the phone, because I need to get some serious things set up, because I'm just dangerously out in the open on some of the things that we've done for lack of this planning. And I think it's great just to hear this stuff and have you come on here, because if I'm failing at this stuff, and I teach a lot of this, like how many, of the other people on here are kind of, left out there without this kind of planning. And this isn't difficult stuff, but it's stuff that none of us are taught. It's stuff none of us really have spent the time to research. And, there's attorneys, and then there's NCH. It's just so much easier if you just use somebody that can set it all up instead of piecemealing things. I'm thinking about all the attorneys I've used, and this one did my healthcare proxy. This one did my will. It's like, then you don't even remember who does it, or the one attorney retires. Look, true statement. And all of a sudden you're like, oh yeah, I don't know where that will is.
Yeah, and there could be conflicting language in some of those documents that was prepared by one, not the other. That's why, some attorneys don't want to author other attorneys' work. So they want to see everything there, so they know what all the different components are. Because if Kurt Harris, who is our attorney, wonderful attorney, looks over, everything and signs off on it, that's his work, right? So if you've got a power of attorney, a financial power of attorney, irrevocable power of attorney set up by this attorney over here, and you've got your healthcare proxy over here, there could be things that related to your finance, like I said before, to your healthcare. How much of your money do you want to burn through before we just yank the plug? And that sounds cold-hearted, but in an honest conversation, we have to think about that. How much of our, family's money, college, education fund, do we want to burn through until we just realize, pull the plug? I mean, look, if I got a blink to communicate, pull the damn plug.
Yeah, I agree. Now, I had sent over a couple questions, because there was a lot of them coming in. I answered the ones I could, but I'm just not an expert in this. I'm the first one to admit it. So I sent them over. I don't know if you have those in front of you, but I have a couple up. One of them I thought was really good. If you give away your vehicle as part of your will, are these taxable to the estate or the person you give the asset to? I thought that was a good question. I had no idea.
That's a great question. So there's again, a lot of unknowns, right? What kind of vehicle, what's the value of the vehicle? So we have to look at all these things, but typically no. So if father passes away and he wants to give his Ford Ranger pickup to my son, it's my son's. So vehicles depreciate for the most part. We'll agree with that, correct? Some appreciate, but most depreciate. So we're not worried about my son getting a pickup that was purchased for $15,000 and it's going to grow in value. So if he sells it, he's taxed on the difference, because that would be the circumstance with any asset, right? So vehicles do depreciate. So over time, yes, if we had a vehicle that was purchased for $15,000 and the time my father passed away, it's worth $6,000 and my son sells it for $4,000. No, there's no taxes involved at all in that circumstance. Now, 67 Shelby Mustang Cobra, right, that's going up in value, yeah, it could generate tax based on the value of death. Step up in cost basis applies to everything, to what it was sold at. So great question.
Yeah. And then, Holly had a great question too. Is there a way to legally hide assets for for college for financial age, for instance. And I'll take that one, Holly. It's easy. I mean, the infinite banking concept, the specially designed whole lives, exempt from the FAFSA reporting. If you got money in annuities, if you got money in retirement accounts, all exempt assets. So find out what assets are exempt from the reporting. So you don't really have to hide the assets. That sounds kind of like, ooh, I'm trying to, do something illegal, but it's fully legal. They write the tax code. We just follow it and learn what those little ways through it are. And those are some ways. I don't know if you've got anything you want to add to, how to position assets, so that it doesn't affect the financial aid for your children, because that's a big thing. And I did a lot of that.
It is. And I think a better way to look at it is let's determine, like you said, what doesn't count, right? What's left outside that doesn't count. We're not hiding anything, because it's perfectly legal to have those types of instruments set up. So we're not hiding it. We're just being very tactful as to what we keep that gets reported. So it's the same thing argument as a revocable or irrevocable, what's in our name or what is disassociated with us at that time. So no, your answer was perfect.
And this one was one I had no idea, but somebody on here, Sandra, said, if you're a disabled veteran and exempt from paying property taxes for your homestead, does that tax exemption change if the property is put in a living trust? I thought that was a great question.
No change at all. The living trust is still you. It's inter vivos. It's still you. So no.
Okay. Yeah. So that kind of answers this one. If a property is in a trust, is the trustee anonymous? That's actually a different question.
It could be. So there's different types of trust, many different types of trust. So if we're talking about what we call a real estate privacy trust or a land trust, the trustee is not private. That's why you want the trustee to be somebody other than yourself. So if you have a rental property and let's just give a scenario. You've got a rental property. It's got a mortgage. The mortgage is in your name. So obviously we know if we take the property and place it directly into an LLC, you could get a due on sell letter from your lender. So we use a legal instrument called a land trust or a real estate privacy trust because in accordance with the 1982 Garn-St. Germain Act, it simply states that you can take an encumbered property with a mortgage and place it into a qualified inter vivos trust, which is the land trust, and preempt the due on sell. Now this only works with 4 units and down. So residential, not commercial, 5 units and up. So in this instance, yeah, that would be a perfect example where the property could go into that trust. There's no reassessment, and then we simply take the land trust and we attach the lifetime beneficial interest to the LLC, which creates the asset protection, death time beneficial to the revocable living trust, and then you will have a trustee. Well, that trustee needs to be somebody other than yourself. In my case, it's my sister. She has a different last name. So I don't want to be my own trustee. Arizona is the only state that requires the trustee to be you. Okay. So you can be, have somebody else, friend, family member, even another LLC be the trustee. Their only fiduciary responsibility, Chris, is not to disclose who actually owns the property. So
and that's fantastic. Then this one said, this is, let's see, would it be all right having your trust being co-owner of your business along with yourself?
I mean, the trust itself is going to do that. So
yeah, that's kind of what I thought. It's its own thing.
Example, LLC taxes and S corporation, you're flipping houses, right? So when we assign the membership certificates to the revocable living trust, that's the continuation plan that we talked about. On the operating agreement, you're still listed as the managing member, right? So it's still you. So you have the best of both worlds. You are the business owner, but the membership is held by the revocable living trust to avoid probate. In partnerships, this is a big issue as well. So if you're in a partnership, let's say you and I go into a partnership, Chris, we have a partnership LLC. Your 50% should be held by your revocable living trust. My 50% should be held by mine. Because if I'm just holding mine personally and I kick the bucket, our business just went into probate. They can't probate half a business. So be a responsible partner. If you're in partnerships with somebody, you either have to have a buy-sell agreement, partnership agreement, or you each have to have a revocable living trust and or both if you really want everything covered.
And then Nikki said, use a will in combination with the trust. I know you kind of covered that, but I just thought maybe a real quick recap of that would be great.
Absolutely. There's, again, The will components are typically your living will, which is your durable power of attorney, financial, medical, your healthcare directive, guardianship rights for minor children. So those are the main components of that will. And then what's called directive cause. I die, here's who gets my stuff, right? That's your typical will. But again, can be challenged, can be overturned. It's a public document, and it has to go through probate. So once we pour that into the trust, that's where we receive the privacy and avoid probate.
Great.
So both.
And then Jeff had just kind of a stat question. He said, is there a stat on the number of probates that happen in America yearly? It's probably staggering.
Oh, it's, I mean,
too many.
Thousands. I mean, I'm one of those people that would venture to say probably 100 every hour. I don't know. I mean, because people just aren't informed. You know, again, you made the point. This type of financial education, the service that you're providing to all of your followers, how long has that been around? Not long, right? So think about everybody that grew up in the 50s and 60s and 70s that are getting into those later stages of life. They didn't have access to this information and knowledge. And again, it's just, you don't see a commercial for Revocable Living Trust and jump off your chair and go get it. It's one of those things that you kind of have to be conned. Hey, let's go to the ice cream shop. The next thing you know, we're filling out paperwork. So people just don't wake up one day and go, I need to do this. They need something like what you're providing to them to say, look, here's what's out there. This is what's going to happen. And this is what we need to do.
And then Lynette had two questions. First one was, a trust should not be in our names. And then the second one is, if you want to change the executor of our trust, do we need to go through an attorney? So I think that's a definite question for you.
Yeah, no attorneys involved for that. You could you make your own amendments to it. I mean, you could do it through our clients, can go right back into our attorney, Kurt Harris, and go, hey, major blow up in the family. This guy's out, this person's in, whatever the case may be. And that's, those things happen, right? How many times do we unfriend somebody on Facebook? We change our minds often. So it's important that we understand it's revocable and it can be changed at any given time. And the first part of her question again?
I think you hit it on that. I think it was basically just saying that, so a trust should not be in our name. A trust is its own thing. It's its own entity almost.
It's not required to be in your name. So why would we want to have it in our name?
Yeah, I wouldn't. Yeah.
Yeah. So when you're out there, trolling for probate, or you're trying to run down title on a property, and you're going to see properties named after individuals, you'll see held in trust but still named after the individuals. And every now and then you go, aha, here's one. This is probably somebody's working with David, right? Or NCH, because it's the Shaggy Dog Family Trust, right? Yeah. So yeah, I think it's important as well as Kurt Harris, our attorney, makes sense not to, put your name out there when it doesn't need to be. Control everything on nothing.
Yeah, exactly. I keep staring at this thing right here that I printed out.
There you go.
And then Sandra said, so when the person dies that owns the trust, how does it pass to the beneficiary?
So let's talk about it. So graduation date happens. And now, as I said, when you pass away, your social security number gets turned off, right? And we generate an EIN number for the trust, for the estate. So everything that's written in the trust is going to happen. So there is no, you see these movies that dramatize it, right? Did you see Knives Out?
I did not know.
Great movie. So, everybody's not sitting around a big desk and there's an attorney there reading everything. It doesn't work that way. That's drama, right? That's drama. So essentially how it happens is beneficiaries are notified upon death of the loved one. They may already know, but they're notified formally. And then it's basically explained to them, what has been left to you. Or what responsibilities are being asked of you if you're going to be a guardianship. Now, in our case, we mentioned our guardians, right, for our children. They already have a copy of that. So if something happens, they got a piece of paper that says, give those kids to us immediately, remand those kids to us. So there's a notification process that takes place based on if you're in state, out of state, in country, out of country, and what is your involvement in the estate, in the settlement of the estate.
Yeah. And, as I was kind of listening through, folks, like some of the just aha moments I had is I'm just thinking, and I'm sure all of you are doing the same thing, because when you're learning, you're thinking about your personal situation. And I'm thinking of how everything's set up. I have a lot of privatized banking policies, a lot. And, even though I don't focus on the death benefit, there's a substantial amount of death benefit. And then I've got a bunch of term insurance to protect all those mortgages that I have, like my rental portfolio. Each one of those is protected by a term policy. So how I'm thinking is, okay, so a trust probably should be created for all the other stuff, as well as making, the trust be the owner of some of these privatized banking policies. I don't lose control with that, but it adds that another level of protection, and then keep all my beneficiaries very streamlined and have the beneficiary go direct to the person that I want it to go to. But if there's somebody like Viviana, okay, 4.5 months old now, killing it out there, but just doesn't need $1 million in her bank account at this point. So I would want that not to be a direct beneficiary to Vivi, but to go to a trust. So, that's kind of how I'm thinking about it, is like from an overall holistic standpoint of, everything you've got, you want to really think about, how does all that work if I'm not here? Today, when I'm driving home, I get hit by a drunk driver. How does all this stuff play out? And how much effort does my family have to go through to basically make my wishes happen?
Yeah.
And I think that's the most important thing is, just.
It is. And you hit on something really important, because you're not actually we never put a liability into a revocable living trust. Your revocable living trust is your personal treasure chest. Yes, upon death, assets do fall in there, but they get distributed out. So what you said was exactly right. So the insurance policies don't and can't create liability. What they are is a mechanism for funding. So the property is not actually that. So it's totally separate. So yeah, that's the exact idea. So your revocable living trust won't even have your vehicles in there, your everyday drivers, because they're more of a liability than an asset, unless you have the 67 Shelby Cobra. So that's just an example of something that you could put in there, and that's something that you want to pass down. But everyday drivers, things that bring liability like that, no. This is all about pure assets.
Yeah, I love it. So, with all that, folks, I don't know if anyone has any additional questions. I thought this was great, but you all need to take action. I know I do. Like I'm the first one standing in line, like for those 10 people, like I need to get my stuff figured out. And it's so easy to be too busy to figure this out. But at a certain point, you just need to carve out a couple hours and literally get the important things done so that you never look back or look down from above or up from below, hopefully not. You never have to do that and say, boy, I wish I would have done that. I shoulda, I coulda, I woulda. And, that's the real thing you got to ask yourself is, are you protected? Is your family protected? Will things play out the way you want them to upon that one graduation date that we can't control? Well, if you don't have the answer, or you don't know, or you're kind of now thinking about it, there you go. Text NCHRLT to the number on the screen, and you guys can set it up just like me. So with that being said, I think this was fantastic, David. I appreciate your time and coming on the Wealth Webinar series.
Absolutely. Thank you very much. Look forward to more of these.
For sure. And folks, thank you all for joining us for another episode, another Wealth Webinar series. We do this every single week, same time, same place. So make sure you join us next week. We're going to have some exciting stuff coming out. We've got some new toys, which you see behind me, and we're going to start using these bad boys. So we'll see you then next week, 1 p.m. Don't be selfish. Share this. Send this to some friends and invite some people to join us next week, because this, like David said, this is the knowledge. Nobody else is out there doing this for you. Nobody's giving this knowledge out for free. Everybody's charging you for this stuff. And here it is, free for you to enjoy. So share it. We'll see you guys all next week. Thank you for joining.